Hello, everybody, and welcome to Data and Technology Transactions in a Digital Age. My name is Kelly DeMarcus Bastide, and I am a partner in Venable's privacy practice located in Washington, D.C., although I am coming to you, of course, from my house this afternoon. Later in the program, you'll hear from my colleague, Chris Kim, and I will let him introduce himself when it's his turn. Just on the housekeeping side, we do have a lot of material to cover, and to the extent you have questions, we love to see them. We'll keep track of them, and to the extent we can't answer them during the presentation, we will get back to folks after via email. So I am really excited to be discussing this topic, which has increasingly become part of the privacy and security practice of which I'm a member. Because of the patchwork of US privacy laws and global laws, it seems like there is a new law coming online every day. Provisions governing data collection, use, and sharing have become increasingly complex and increasingly important. I am not a contracts expert, which is something you're probably going to hear me mention a few times, but I do have subject matter expertise in privacy and data security. So due to the increasing complexity of these types of provisions in agreements, my group, the privacy group, are increasingly being called upon by our colleagues to advise on provisions in contracts related to privacy, data protection, to use kind of the term that's used in the rest of the world for privacy, and for security, and to frequently advise on whether more is needed in an agreement or less is needed under a particular fact scenario. And then, of course, to help cut through negotiations when it's hard for the parties to agree on data usage or sharing rights and obligations. The kind of more or less is really important in this particular space, as nonprofits are exempt from a lot of US privacy laws. Typically, under most global privacy regimes, the compliance obligations flow from the primary entity, the controller, to use language that's used pretty commonly globally, to the vendor, processor. Nevertheless, despite the fact that vendors should be taking cues from their clients, vendors are frequently seeking to impose contractual terms to meet their own perceived obligations under laws, regardless of whether the client is subject to laws. And I'm sure many folks who are listening in today have encountered that scenario, especially around the California Consumer Privacy Act, or the CCPA, which is now kind of the major US privacy law and does not apply to nonprofits. Okay, so let's dive into the privacy aspects, and then later we'll talk more about the commercial aspects generally. Thanks. Next slide, Chris. So again, I do not approach this from contracts expertise, but when I'm called in to look at an agreement, I wanted to just outline at a basic level some of the steps I take as part of my initial approach. Of course, we should start with what side you represent. And it matters because, as I said, most of the primary privacy or data protection obligations are imposed on the controller and not their service provider. And we will unpack those terms a little bit. But depending on whose paper you're looking at, it's obviously favorable to one side or the other. And in the privacy context, that relative favorability can mean shifting certain primary regulatory obligations from the party to whom they belong to the other party, or vice versa. This is usually fine under privacy laws as long as the parties are comfortable with that kind of arrangement. So I sort of, of course, flag the provisions that are relevant to privacy and security for review. Frequently, especially with security, it requires subject matter expertise from the client because security requirements are sort of company specific. Most major laws in this area require only, reasonable or appropriate data security safeguards, and each organization, of course, has defined what that means for them and what that might mean for the data at issue in a particular agreement. So it frequently requires expertise from IT or someone to look at those particular provisions. And then on the last point, it's really instrumental to understand data flows. Agreements, frequently now we're seeing more one size fits all, where an addendum is intended to cover kind of all of the laws globally, possibly. But the flows matter because the applicability of certain laws are triggered by where the data is coming from, what consumers, where they're resident, and how that impacts. So data localization is also becoming increasingly important. So it's really important to understand the data flows. Sometimes you can excise entire portions out of a one-size-fits-all agreement because, for example, EU data is not coming into play in a particular arrangement. Also, privacy laws are becoming increasingly a bit dogmatic on things like record keeping and accountability. So there was a time not so long ago when it was fine to say, hey, we're working with a sophisticated vendor, they're taking care of that for us. But it could be that if your organization is covered by certain laws, you have your own independent record keeping obligations, and understand that the data processing activities and the flows are instrumental to you keeping your own records to comply with your legal obligations. Next slide. Okay, so just digging a little more into some of the specific terms for review. At a high level, these are generally the terms that I look at. Let's talk a little bit about compliance obligations, and it's something we're going to spend a lot of time on here. At least from a US perspective, most nonprofits have relatively few legal obligations due to nonprofit status under US law. And where we're increasingly seeing some friction in the process is, can you make the vendor understand that? And if so, are they willing to strike entire aspects of an agreement? Or alternatively, can we modify the language to make clear that you're not sort of voluntarily agreeing to a legal standard, but perhaps you're comfortable taking on some of the substantive obligations that the legal standard would require? And a lot of time, I think, I'm increasingly being spent on kind of navigating that balance. Finally, sort of a plug here for terms related to data related or privacy, self-regulatory compliance. Another area where organizations might not have a lot of visibility, but it's important. There's a number of self-regulatory regimes, frequently in marketing, advertising, SMS marketing, and your vendors may be signatories to those kinds of agreements. They frequently impose requirements that are even stricter than those that are required by applicable law. And vendors may have their obligations or be required to pass those up to their client. So it's important to know what you're agreeing to when you sign on to those kinds of provisions. Okay, so let's do a little bit of a deep dive on the regulatory compliance point. Next slide, please. Okay, so how do we approach regulatory compliance? Obviously, we have to start by figuring out what laws apply to you and excluding the laws that don't apply. We have talked about the CCPA, which is currently the most restrictive law in the United States. For those of you who are following, the CCPA will be replaced by the CPRA, the California consumer, I should know, it's the CPRA, and Virginia also comes online in 2023. The CCPA and the CPRA have broad nonprofit exemptions. Virginia's exemption is a bit narrower and only exempts 501c3, C6, and C12 organizations. So if you are, for example, a C4, you will become subject to Virginia's privacy law. There's also a new law in Colorado, similarly broad exemptions, and a number of bills pending that are close in a number of states. So it's really an area to watch because new laws truly are coming online almost every day. We'll also see regulations for the CPRA, and Virginia has not issued any regulations yet. So that's a space where sometimes the high level principles of particular law are fleshed out a bit more. The GDPR is another law that's really important in this context. It does not have a nonprofit exemption. We have counseled a number of nonprofit organizations on GDPR applicability, but I will say it is both broad, but not as broad as people think. It's not triggered merely by the collection or processing of EU personal data. It's a more fact-specific and nuanced analysis. Organizations can frequently sort of tailor their practices in a way as to escape GDPR applicability. That's desirable to the organization. And, it's important, I think, for your organization to understand where they fall in that landscape and whether they're subject to the GDPR, which applies from a contracting perspective, some of the most onerous and complex provisions in the privacy space. And then other US laws here are usually subject to a US law either because of the data at issue or the type of entity you are. So the former, we have COPPA here, that's the Children's Online Privacy Protection Act, and it applies to the collection of personal data from a child online under age 13. Another example, the Fair Credit Reporting Act applies whenever you use information that's obtained from a consumer reporting agency or CRA. And then on the other side, due to the status of an entity, that's a law like HIPAA that applies to healthcare providers who are collecting or processing electronic PHI, personal health information, or GLBA, Gramm-Leach-Bliley, which applies to financial services providers. Okay, so once you know the laws that apply to you, you have to understand, of course, the contracting implications of being subject to that law. And certain laws do have specific contracting implications to understand. Just to go up and flag that middle bullet there about considering the risk. I think so far we have sort of assumed a paradigm of the nonprofit being the client who's engaging a vendor, but I have worked with a number of nonprofits who are actually the vendor. I think especially our association clients. A number of you offer testing, credentialing, coaching, those kinds of services to your members. And in the course of those services, you may receive personal data associated with, employees of your members, for example, in a role as a service provider or vendor, in which case you're the ones who are sort of being the recipient of this kind of agreement, and it might make sense to have your own kind of form DPA or data protection agreement in place. Slide, Chris, please. Okay, a little more deep dive on the regulatory point. So once you have decided or determined the applicable law, we all know, of course, there are certain privacy obligations that are pursuant to each law. However, the contracts can be used to allocate responsibilities for compliance under the law. A couple examples here. A common one is breach response. Every major breach law globally, of which I'm aware, all the ones in the 50 states plus Puerto Rico, GDPR breach notification, it is a kind of two-tiered notification. The service provider, vendor, processor is required to notify the data owner. That data owner has the ultimate legal obligations for notifying affected individuals and or a government or regulator if required under the applicable law. That's the way it works under the law, but contracts can often allocate this a little bit differently. It's relatively common to see the primary entity push the actual work of the notifications, the consumer-facing notifications like printing letters and mailing them out, to push those back on the vendor. And that can be allocated via contract. That's perfectly fine if the parties agree. Another is responding to individual rights requests. A big trend that we see in global laws are giving individuals rights over their personal data. So a right to access it, a right to receive a copy of it in a portable format, a right to request deletion. The rights vary a little bit depending on the law at issue, but that's the general idea. Again, it is that controller client's obligation, because it's their data, to respond to those requests, but via agreement, they can push the actual work of building the response onto the vendor who might be holding the data and databases on their behalf. So again, something else you might see in contracts. There are often ways to mitigate the requirements of requirements under the law. Cost shifting or indemnification is the most common way to do this. Most global laws that set up a two-tier structure make that data controller fully responsible and liable for the acts of the processor acting under its instruction. And we do see indemnification commonly in that context to try to shift some of the costs that might arise out of a regulatory investigation or penalty. Another example are audit rights. GDPR requires that controllers have rights to audit the data processing practices of their vendors or data processors. It's a pretty unfettered right as written in the GDPR, but there are ways to try to lessen the impact, like limiting the frequency, asking that data controller, give 30 days notice before an audit, shifting the cost of an audit or employee time if they have to be involved in an audit, having the controller accept kind of third-party standard written documentation that has been built in other contexts in lieu, at least, of an initial audit. So there are things that have popped up in the marketplace that we see as a way to kind of, lessen our shift impacts under applicable laws. And it's important for your organization, I think, to understand kind of what they want to accept in this context, or kind of how far they want to push these kinds of limitations. Next slide. So we have been talking, or at least I've been talking, about a pretty simple bilateral agreement. There's a controller, client, data owner, and a vendor or service provider processor on the other side. But this slide is just to point out that there are different kinds of contracting scenarios that we see less commonly, but still exist. For example, it might be multiple parties, things like data co-ops, where you have a number of entities who all agree to put their data into a shared pool, aggregate it, and pull out insights that are relevant to all of them. Less common, but still the kinds of arrangements that do exist. Frequently, external terms are referenced in contracts, but not be provided. You have a supplier code of conduct, an acceptable use policy, privacy policies. It's not uncommon to see those, compliance with those external documents being pushed through in the contract. And then where we'll spend a little bit of time, what we call the formulaic contracts, DPAs, data processing agreements or addendum, largely grown out of GDPR requirements, but have now become a little bit of a standard way globally to present privacy terms, and frequently attach to them something called the standard contractual clauses, which I will talk more about in a bit. Okay. So next slide, I wanted to shift the focus a little bit and talk about the two major privacy laws that clients are frequently dealing with. They're the primary drivers of privacy obligations and are models in their respective spheres. Most countries that follow a non-US approach follow the GDPR for the most part. You all might have been dealing with Brazil, which became enforceable last year. That is largely a GDPR copy with some changes. Korea, Japan all follow a GDPR model. India's bill follows a GDPR model. And then in the United States, the CCPA became the first comprehensive privacy law in the US. Virginia and Colorado, the two laws I mentioned that will go into effect in 2023, follow a CCPA model. And most of the bills we see are kind of, again, CCPA knockoffs. So understanding these two regimes get you pretty far in understanding global obligations generally. Okay, so next slide. Let's start by defining who the key players are. I've used a lot of terms interchangeably, like service provider, vendor, business, but let me get a little more careful about who the parties are under the respective laws. So starting with the CCPA, and this all, of course, goes to the exercise of understanding the parties and the data flows, which is instrumental to understanding the context for the contracting. Okay, the entity that's primarily regulated by the CCPA is the business, and they are the party that collect personal information and are subject to the CCPA. Their vendor is a service provider, any entity that processes personal information on behalf of the business. And importantly, a weird quirk of the CCPA is that to be a service provider, you're required to have a written contract that prohibits that service provider from retaining, using, or disclosing personal information for other purpose other than performing the contracted for services. So you need both the functional definition as well as the paper that memorializes those restrictions in order for someone to be a service provider. Why does it matter? Because transfers to service providers are not sales, and sale is a very broad, fraught term under the CCPA that triggers a whole host of additional obligations. So to the extent that you want to use vendors, and everybody does, having them properly bound by contract is really instrumental. Again, sort of acknowledging that nonprofits generally are not subject to the CCPA, it's still really common for for-profit service providers to put the CCPA language in their agreement, because they have effectively a one-size-fits-all agreement. I think for the most part, if you're working with a vendor, it's quite all right to agree to those substantive provisions, the prohibition on retaining, using, or disclosing personal information for any purpose, because that's what you want your vendor to be subject to, that kind of limitation. What you have to, of course, watch out for is anything that makes it sound like you are agreeing to be subject to the CCPA by contract. But you can usually walk that tightrope and strike the legal reference, but kind of keep the substantive point. That will make most vendors happy in this space. CCPA also recognizes another category called a third party. It is confusingly defined in the negative as an entity that is neither the business nor the service provider, but that processes personal information. Crucially, third-party designations are not limited to for-profit entities, and it can be any entity can be a third party. Third party effectively has full rights of a business, but doesn't acquire the data directly from consumers. So think about a data broker or data aggregator. They're kind of your prototypical third party under the CCPA. And consumers, of course, are natural persons who are California residents. Okay, next slide. Same terms from the GDPR context. Data controller, it's the party, again, who makes those key determinations of a data processing, and the technical definition is that they control the manner and means of processing, and the processor is that entity that processes personal data on behalf of the controller. Not the same CCPA requirement where you have to have kind of an express designation to this point. But importantly, controllers and processors have to be bound by an agreement, a DPA, that outlines very specific requirements and allocates them to the parties. And again, this now applies to nonprofits as well. The GDPR has no nonprofit exemption. There's also a recognized party called a joint controller, and that's when you have more than one controller who are sort of jointly making those determinations about data processing. They can either, kind of do that hand in hand, or have what they call converging decision, which is sort of parallel tracks. Converging decision is something like, think about a clinical trial where there might be multiple medical entities all collecting the data. Maybe one is, analyzing it for X and one is analyzing it for Y, but essentially they're getting the same pool of data. If you have a joint venture or a joint privacy policy with someone, you're probably a joint controller for GDPR purposes. I will say it's also a bit of a fraught distinction. It's relatively rare. And if you're served up a DPA that has you being a joint controller with somebody else, I would say look at that very closely and see if you can strike the joint provisions. Just be confident that you really meet that, because we'll get into it, but it requires a little bit of contracting complexity. Next slide. So as I mentioned, we talked about what CCPA agreement for service providers requires. It's very light. It's that restrictive prohibition on data use, disclosure, or retention. GDPR Article 28 requires a DPA between controllers and processors. It has a far greater number of obligations. This is some of them that are material. There are a number more. I think there's about 10 substantive obligations in all. So GDPR and CCPA don't really meet up from a contracting standpoint, but it's pretty common to see a single agreement handle, both laws and other major privacy laws that follow both of them. So if you are an organization that, for example, is not subject to the GDPR, you can generally strike all of the items that are on the left-hand side of this slide if your vendor is amenable to that kind of markup, or alternatively, try to couch the agreement some way so that they apply only if GDPR is triggered. If you have an understanding that GDPR won't be triggered by a particular agreement. Okay, next slide. So to sort of wrap up, just a little bit on some specific contracting scenarios. We had mentioned that there are some kind of oddball, non-traditional bilateral agreements. One is the third party, which we mentioned under the CCPA. And as I said, a third party does not have to be a for-profit entity. Essentially, if you're a third party, there is a unique requirement that applies, which is if you resell information that you have acquired not from the consumer. So again, that sort of traditional data broker, data aggregator, reseller role, you're required to provide explicit notice to consumers. How do you do that when you have no touch point with the consumer? Is an excellent question. The CCPA regulations have dealt with that by allowing third parties to deal with notice requirements by registering as a data broker in the state of California. This is a kind of a strange little corner of the CCPA, but it is what it is. And, you know, if you are served up an agreement that have you in a third party role, it's something to think about because it will have sort of additional obligations going forward. Explicit notice, of course, is a term that is not defined in the CCPA, and this is the only place that it's used in the law. GDPR, I have controllers question mark because a DPA is required in a controller processor scenario. The GDPR itself is silent as to what happens in a controller to controller scenario. I see this most common with our nonprofit clients, associations that do trade shows, for example. You know, of course, there are sponsors of those shows. Those sponsors want attendee lists, attendee data lists. They're going to use it for marketing. That means they're a data controller and that they're not in a vendor role. So the question is, what kind of agreement do you put in place for that controller to controller transfer? GDPR doesn't say. So sometimes you see kind of a stripped down version of a DPA. Sometimes you see simply one line, you know, both parties agree to comply with all applicable laws. I think what's important to understand about a controller to controller transfer is if party A and party B are truly separate controllers, they're responsible for their own legal compliance under the law. And kind of once party A transfers the data to party B, they can sort of wash their hands of it effectively. Party B now has to comply with the law respective to that data. And then we mentioned joint controllers. Why is the contracting fraught here? Because the GDPR says that the parties have to look at all aspects of GDPR compliance and contractually allocate who is going to do what. So, for example, privacy policy, you know, you're supposed to put a chart in your contract that says the privacy policy will be issued by controller A or jointly by A and B. Who's going to respond to data subject access rights? Well, maybe that's controller B and not controller A, but you're actually supposed to work hand in hand with your joint controller and kind of allocate substantive responsibility under the law. You can see how that could be a little bit of a mess. So like I said, joint controllership, if you can avoid it, do so at all costs. And then last slide for me, one thing I wanted to mention are the standard contractual clauses. EU data protection law requires that personal data be stored physically in the EU, and that means access. So even if your data is on a server in Europe, but you have someone in the United States who can log on to that server and look at it, that data is being transferred to the United States. If a transfer is happening, it can only do so according to an appropriate safeguard. There is a long history of courts in Europe looking at various safeguards. The net result is we generally are left with something called the standard contractual clauses. These are form contract provisions that govern the cross-border data transfer. If you've seen an EU DPA, that's the 14 to 16 pages in a strange font that are appended at the end that your vendor might tell you, hey, you can't edit those. There are some appendices to fill out, but it's true, they can't be edited. This has been a real problem for some time because the standard contractual clauses were put into effect in 1995 and they were not updated for GDPR. They were, in fact, really not relevant for kind of the world where we all live. They were very bilateral, they were very formal, and because they couldn't be edited effectively, a lot of organizations were in a position of you have to execute them even though they weren't quite right for the scenario. This has been remedied. There are new standard contractual clauses that came out at the end of June. You can continue to use the existing ones through the end of September. But once September 27th occurs, folks have about 18 months until I think it's December 27th, 2022, then to replace all versions of old standard contractual clauses in agreements with the new SCCs. So we do anticipate there's going to be a big uplift in contract changes and kind of reopening existing agreements going forward, kind of starting in Q4 of this year and all through next year. The new SCCs take a modular approach. So there are different pieces that apply in different fact scenarios. We have SCCs for controller to controller, controller to processor scenarios, but also a processor to processor scenario. For example, if you have a sub-processor, so if you're a vendor, but your data is being stored in Microsoft Azure, that's a processor to sub-processor scenario. And then processor to controller, again, a new module that didn't exist before. This is like your marketing vendor is collecting the data on your behalf in the EU and holding it on your behalf for marketing purposes, processor to controller. So they're not quite as easy to implement because folks will have to select the correct scenario and, you know, kind of pick and choose the pieces and build them. But like the old SCCs, once you have the module in place, they can't be edited. They have added a new wrinkle though, which is before you use the SCCs, you have to do a formal assessment of the laws of any third-party country, third-party non-EU country where the data might end up. So in the United States, this means you have to do a formal assessment of whether government surveillance laws like FISA 702 or executive orders that permit government surveillance would apply to that data. These transfer impact assessments are becoming really common now. I've done about 12 of them in the past month. So again, I think expect to see these. And if you're an organization that relies on the SCCs, prepare to do one of your own going forward in the next year or so. I think that's all I have. So I will over to you, Chris.
Thanks so much, Kelly. So my part of the presentation will be focusing more on the traditional commercial contracts provisions and how they overlap with all of the, or many of the different data regulatory topics and privacy topics that Kelly went through. Because as you guys may know, especially those of you who are familiar with contracts review, commercial service contracts and other scenarios, particularly in IT services and software as a service, there are a lot of more long-standing provisions that have frequently been a feature of these types of contracts for many years, and how they interact with the data privacy concepts and the new types of contractual provisions that are now required, or at least encouraged under emerging developments in data privacy law. There's a very diverse set of approaches, and hopefully this part of the talk will help you to identify where and how these different types of provisions will overlap with, or potentially supplement, or even in some cases conflict with the new types of provisions that we're seeing. So a little bit of background on myself. My name is Chris Kim. I'm an attorney with our firm's IP Transactions Group, together with the Technology Transactions and Outsourcing Group. Kelly was being very modest at the beginning of her talk, saying, oh, she doesn't review things like a contract expert. She's actually very good with contracts. I know that from experience. But to a certain extent, I'm also, or definitely the transactions specialist or expert on the presentation. So I work together with our privacy group and many other groups of the firm to review these types of transactions from that perspective. In addition to the traditional commercial contracts issues that we always have to look at, we also take a look at the specialized contracts provisions that are meant to address liabilities and obligations related to data privacy and especially security breaches. So with that in mind, I wanted to go to the first and probably most important, or at least most heavily negotiated set of contract provisions that you'll see. And before I get into each of these provisions, a quick note, even though it's not on the slide, about structure. Contract structure is an increasingly diverse thing when it comes to vendor contracts when you're on the customer side. Some vendors, particularly smaller ones or those that have a more traditional view, will still go with a very conventional, giving you an actual discrete contract form that has all the provisions in it and all the attachments to it. And then once you've negotiated and agreed to it, both parties execute it and have a print copy or PDF of the contract. However, in IT services and software related services, as you guys may know from experience, that's becoming the minority. And now what you see are a lot of order forms, purchase orders, smaller contracts that look innocuous at first, and then they link out to a bunch of online hosted terms. They reference a bunch of external supplements. And the purpose of that structure is twofold. First, it's from a sales strategy perspective, it makes the contract look a lot simpler than it actually is. And then secondly, it gives that, and probably more importantly from a legal perspective, it gives that vendor the ability to modify those terms that they host online. Now, in some cases, that desire for flexibility is innocent because they're aware, similar in privacy, that the regulations are constantly changing, and it may be that a new law is enacted that requires them to make a change that they can't afford to go out and individually negotiate with each of their customers. However, for the lion's share of these provisions, I would say that it really is that they're just looking to give themselves a commercial or legal advantage in order to give themselves the maximum amount of leeway to transform their legal terms on the fly. And I would say that information security and data privacy is one of the biggest negotiation battlegrounds, biggest, most emergent sources of potential liability and conflict when it comes to this type of structure as well, because a lot of customers, including those who operate in the nonprofit space, the association space, they don't want to be subject to a series of obligations or liability standards that are hosted online that they don't have visibility into, that might change without their consent. And so please do keep in mind with any of these provisions that whenever you're reviewing these contracts from the perspective of a customer, you need to take a look at all of the hyperlinks, all of the different references and attachments, because oftentimes the major data privacy related sections will be found in something other than the main body of the contract, sometimes even something other than the contract file that's presented to you to sign. In fact, many times different from that package. So please do keep a lookout and do your diligence, because courts, by and large, in recent cases, have found those types of structures to be enforceable, especially when sophisticated parties are at play in an arm's length business transaction. So keeping those structural considerations in mind, like I said, I thought I would start with the most important types of provisions first, which would be the liability-related provisions. And quickly, before I go to each individual type of provision, I did want to make a bit of a distinction here between both on a technical level and on a legal level, what we might call a data breach, which is the kind of the fact of there being an unauthorized disclosure of data that may have been regulated or created a liability for one of the parties, versus a contract breach, which is a material breach or a breach of the actual provision of the contract. Because just because there is a security compromise that results in the unauthorized access of data, that doesn't necessarily mean that the contract, especially a services contract, was drafted in such a way that that data breach in and of itself creates a contract claim or gives either party a right to terminate the contract. It really depends on what the contract actually says were the parties' respective responsibilities. And in certain extreme cases, the contract may not appropriately address even violations of applicable law and regulations in a way that divides up the liability for those violations correctly between the parties. And that is largely a function of distinctions in the defined terms and wording of the contract and the appropriate provisions there. And also changes between how the contract defines what a security breach even is. And one, there's no really categorical way to go through all the different permutations of that definition. But one big substantive practical definition that's often found in contract language for data-related services is a security breach where the definition of the breach in the contract relies on the fact that someone actually did something wrong, meaning they breached the contract, they had an obligation to keep the access to the appropriate individuals or to keep the data safe and confidential. And then it can be proven from an evidentiary perspective that they materially breached that provision in the contract. And then that's where all of the liability provisions will kick in. The other side would be a more strict standard that defines it as just an actual or technical or factual security breach, meaning it's not so much about whether or not they technically comply with all of their stated security obligations or provided the correct type of audit or had the appropriate type of systems that were agreed upon at the time. What matters to the parties from a liability perspective is whether the security was breached, whether there was an unauthorized disclosure. As you can imagine, that latter type of stricter standard is more favored by customers when it's their data at issue, and it's something that vendors are very reluctant to provide. When it comes to liability, they want to say, we're going to try our best, we're going to meet up by the standards that we've agreed on, but we can't promise you that there's never going to be a security breach because someone might be able to get on our system. And that's often the vendor argument, that it's not possible, it's not technically possible to guarantee it. And even if it's not technically possible in the practical world, that doesn't mean that their contract couldn't say that they would be strictly held responsible for that type of breach. So please do keep that distinction in mind when you're reviewing even just the definition or the contract's account of what a security breach even is. And likewise, there are different timelines and mitigation approaches that would be defined out procedurally in the contract. Kelly already did a good job of describing how the regulations sometimes prescribe certain timelines and procedural obligations of their own. But keep in mind, too, that the DPA or the security provision of this contract could contain obligations that are greater than what the law requires, specific timelines and notifications that, even though it's not strictly what the CCPA or GDPR demands of the parties, it's still something that would be expedient for the parties, that would help them to be able to mitigate the damage in a more effective way. So please, and this is going to be a recurring theme for this part of the talk, please maintain and understand a strong internal distinction when you review these contracts between what the law absolutely requires, which subject to those interpretations of the government, and then what the contract requires, which is the agreement between the private parties and what they're going to do, perhaps above and beyond what the law strictly requires. Similarly with limitations and disclaimers, again, it's a familiar concept in the commercial contract space, but it's becoming increasingly tailored to very specific confidentiality and information security liability concerns. Many of you may be familiar with the exclusion of special damages, meaning that often totally capitalized paragraph in the contract that says that neither party will be responsible, or one party will not be responsible for special, consequential, indirect damages. Once treated as kind of an afterthought boilerplate provision, it's actually become very important, because in a confidentiality information security scenario, it's difficult sometimes in a litigation context to assign the concept of direct damages to a security breach, because sometimes it's not really that the value of protecting the confidentiality of the information was built into the fees paid for the service, for example. So it can be a big obstacle to appropriate recovery in a serious litigation or liability scenario if those types of damages are excluded. This is not a fully settled situation from a case law perspective, but because of the ambiguity there, we very often advise customers especially to create specific carve-outs for confidentiality and information security related liabilities from these types of otherwise boilerplate, very standard exclusions. Exactly the same thing with liability cap. If I was to nominate a single provision that is most negotiated, or at least most adversarially negotiated in customer vendor relationships in this space, it is the damages cap, because that is ultimately the ceiling that applies to both parties' liabilities for all of the different types of breaches and third-party indemnities that it applies to. And very often a vendor will come to you with their standard contract form that says, it doesn't matter where the liability came from, whether it was a security breach or whether it was just a warranty breach or anything in between. We're giving you 12 months or 6 months or 24 months fees paid. You get your money back. And then after that, it's every man for him or herself, meaning they just go and take care of their own liabilities, their own potential third-party claims from a security breach without regard to any amount after that 12-month fee cap or fixed fee cap. And the customer preference on the other side is to say, no, I mean, maybe liability caps like this with hard dollar values or month-based fee caps are going to apply to more conventional material breaches of the contract, like when the services are provided in an unsatisfactory way. But when it comes to these special types of damages, these special types of liabilities, we want to have an expanded scope of protection, ideally uncapped, but typically where the parties will end up compromising. And this is very much a case-by-case thing, depending on the risk tolerances of both parties and the type of the services. But often the compromise between customer and vendor will be to find some kind of multiplier of the original fee cap that applies in these special information security breach scenarios, to assign just a fixed value that's higher than the other fixed values, or to make a reference to the insurance policies of each party. And I'll speak a little bit more about insurance later if time permits. And then also please keep in mind specific disclaimers as well. Hidden throughout all different types of provisions in the contract, especially for data services vendors, will be disclaimers that try to exempt them from certain legal standards, certain types of security obligations. And so the contract needs to be reviewed very carefully for superseding language that really tries to mitigate some of the technical controls and technical commitments that vendors have made to customers in this space. Moving on to indemnification. Indemnification is, again, another tricky issue and is very much tied up with the conversation that you have in liability cap, because as you may know, a indemnification that's capped at an amount that's too low to cover an actual claim is not really worth the paper it's printed on, so to speak. So you need to make sure that those two types of provisions are being negotiated and reviewed in tandem with one another. And in terms of different categories of indemnification, we can look at a general material breach, which is just to say a party will indemnify for third-party claims related to its breach of the contract, versus a security-specific breach, which may call out particular scenarios, particular types of violations of law, privacy regulations, or a failure to follow certain procedures. And the specificity of the indemnification for security should go hand in hand with the specificity of the data-related services. If data handling is incidental to the service, then maybe you can go with a more general description of third-party claims that should be indemnifiable. But if it's a very much a data onboarding or processing service, you may want to take a deeper dive into specifically addressing the types of breaches and technical failures that would give rise to a third-party claim and then subsequently indemnification. And keep in mind, too, that there may be some overlap as well with IP infringement indemnification or infringement of the proprietary rights of a third party. Proprietary rights of data is a tricky thing, and we'll speak about that in a moment. But keeping in mind, too, that regardless of how difficult it is to define legally, it's very easy to overlook the fact that each party views or even third parties may view data as their property, whether through trade secret or some other contractual method. And finally, government fines and investigations. Again, as Kelly said, many of your organizations are exempt from the more exhaustive investigative efforts and potential penalties under more specialized regulations, but it is still a type of liability that you may want to call out in the contract. And I spend much time on this slide because I viewed it as kind of the biggest one, but we'll go into other topics as well, especially confidentiality. So confidentiality is interesting because this is a type of provision that's been a feature of commercial contracts for many years, for a long time, certainly much longer than a newly emergent data security type of provision in the main body. But it's interesting because a lot of vendors or even customers will just sort of copy paste the confidentiality provision into their template and then not really think too carefully about how these definitions overlap with the data concepts that are more specifically described in the DPA or the main body of the contract. And even though from a negotiations perspective, this may not always be flagged, it can create a bit of a confusion or even an internal inconsistency between the two provisions about to what extent data is treated as confidential information and to what extent the procedures that are specific to data, capital D, however that's being defined in the contract, will supersede or overlap with the procedures that apply to confidential information generally. There are a variety of approaches here. One is just a full segregation of the two concepts, which is to say the data as issue for avoidance of doubt is not confidential information, and never these two provisions and procedures will meet. It's a clean way to do it, but then you have to make sure that those procedures are being negotiated in a very independent way that's true to perhaps the confidentiality of the data if it's not being expressed in a more general confidentiality provision. There's also the full overlap approach on the opposite end of the spectrum, where data is confidential information and both sets of procedures apply. It definitely gives the parties recourse to a variety of provisions that they could potentially enforce against each other, but could also create confusion if the procedures are not consistent. When you're dealing with an item of data and then they say, well, a common example would be return and retrieval, where data under the data section says that you get to ask for the retrieval in a 30-day period, and they're obligated to keep it for a certain period of time, and then they give it to you pursuant to a certain process or format. But then the confidential information section says that they have to return it to you immediately as soon as you request it. Which one of those two procedures control? Do they actually overlap at all? So that could be a concern there. And then a hybrid approach, of course, is the limited overlap, which is a little more precise. It says data is confidential information, but certain procedures and obligations will supersede the other because the data is a special category of confidential information. So I encourage, we don't have time to go through all the permutations of this, but I encourage anyone reviewing these contracts to evaluate the advantages and disadvantages of how much overlap you want to have between these two concepts, and also consider how much this overlaps with external sources of confidentiality obligations too, whether that's your pre-existing NDA, a DPA form that may or may not be attached to this contract, as Kelly was going through before. And note also the distinction between a confidentiality provision and an information security provision, sometimes also just titled a data or data privacy provision. Again, these, like I said before, it's structured. These types of provisions are not always titled or structured in a consistent way because they're newer. And so you always have to be on the lookout for novel terminology and recognize it according to its subject matter, rather than a series of defined terms that you would immediately be familiar with, like confidential information for that matter. Proprietary rights and data could merit its entire presentation by itself. I will try my best to be quick about this from a contracts perspective. The big thing, I'm also an IP attorney, and the big challenge here is that data is valuable. Nobody argues that. Companies spend millions, if not billions of dollars transmitting it and processing it for each other. But how does the law define the asset? And again, without making this too much of a legal theory discussion, the short answer is not very well, and in some cases, not at all. Certainly, intellectual property law, traditional understandings of copyrights, patents, trademarks, and even trade secrets have not really caught up to the idea of data as a monetizable asset. And so as a result, the contract language that dictates the parties' responsibilities when it comes to data onboarding and processing is disproportionately important to defining how the parties treat the data as an asset. Because the contract itself can create a series of obligations that, even though there's no statute to come in and kick in, like the Copyright Act or the Patent Act, that will save either party when it comes to their understandings of who owns, quote unquote, or who is transferring or licensing data. There is a bit of a license vocabulary that has developed around data that, even though it's not new, or excuse me, it's very new and it's not very established, and even though it hasn't been heavily litigated and there's not a lot of precedent behind it, there are certain understandings about how to technically describe what the parties are doing with the data in a way that makes sense and corresponds to the high monetary value that the parties are associating with that data and the high liabilities that apply to it too. You have to make an understanding also between the system and platform access versus the data access. The software access is something, again, where the licensing language is a little bit more established. And sometimes, in extreme cases, a vendor will have the appropriate license access to you, but they will not actually include a data provision in the contract that correctly identifies the type of data that's being provided and the parties' rights and responsibilities with that data. And when you leave data rights unspoken in a contract, a service contract, regardless of what type of entity you are, by the way, whether it's a nonprofit organization that doesn't have an independent for-profit motive to monetize the data, all the way to a very sophisticated for-profit corporation, or a very large anyway for-profit corporation, and anything in between, you need to have a provision here that directly addresses what the parties can and cannot do with the data, because unlike, like I said before, copyright assets, other types of IP assets, there are no statutes and default rules to come in and kind of redefine the parties' relationship in the event that the contract doesn't say anything about it. Think also about, a lot of kind of terms that are borrowed from other IP regimes, like modifications, derivative works, copies, reproductions. I mean, we don't have the type of copyright-based, patent and trademark-based precedent that really clarifies what that means in the data context, but that doesn't stop contracts from defining them and describing them in this way. So a proprietary rights discussion in data from a contracts perspective has to go hand in hand with the business rep or the technical rep who is able to clearly explain to everyone involved exactly what the scope of access is and how the parties view the value and the nature of the data being transferred. And that needs to be memorialized in the contract in an effective way, because the legal language, as I said before, in contracts has not really caught up. And in my opinion, the more specific, the better when it comes to defining proprietary rights. Moving on to representations and warranties. This is another big one that service providers will often focus on, and especially when it comes to the potential liabilities and damages in a direct contract claim. You want to make sure the representations and warranties are robust so that you can hold vendors to a standard that's appropriate to the sensitivity of the data that they're handling on your behalf. You have your compliance with law. As Kelly said, it's very often helpful to specifically call out the types of privacy laws that you're particularly concerned about. You have compliance with specifications, which is commonly a feature also known as a performance warranty or services warranty, when they say that they're going to perform the services in the way that the contract says that they will. But keep in mind, too, that that needs to interact with your DPA or your other security specifications. When they're standing behind their warranty, you don't want them to exclude the security obligations from that warranty. You want to be very specific of saying all of those obligations fall under the warranty that they're providing to you. Non-infringement can be expanded also to include privacy rights, and very often we counsel customers to not just say intellectual property rights when a vendor represents that their services will not violate or infringe. We should also call out personal and privacy rights or other types of proprietary rights to make sure that we're capturing the full scope of things that in data we might be concerned about. And then antivirus, this is a common request when we deal with technical services, especially software as a service platform, making sure that your access to that service does not infect your system with different types of undesirable malware or disabling devices or other types of code of that nature. And do keep in mind that this antivirus warranty may overlap with an independent security evaluation by your IT professional or even a DPA or a security attachment. And the way that those two types of obligations overlap with each other is an important thing to keep track of in these documents. Insurance will probably be the last thing that we get to talk about due to time. And I just wanted to say quickly that this is sort of the third major component of the liability discussion. Before we spoke about the other two, which are indemnification, limitation of liability. Insurance merits its own slide because it's often the most complicated and requires the most stakeholders to weigh in on it because it's not a pure legal question. It's not even necessarily a pure business or finance question. A risk management or insurance professional should also weigh in when there are major insurance obligations present in the contract. But from a broader commercial perspective, contractually mandated insurance coverage is often a way to try to mitigate liabilities ahead of time when it comes to things like data security breaches. You actually have many insurance providers offering what's known as cyber insurance, although there's a lot of diversity in that market. And please do your research independently on that. But generally speaking, I mean, many vendors will be procuring different types of commercial liability insurance, cyber insurance, errors and omissions insurance, and umbrella insurance that either cover or purport to cover security breaches. And you want to see, oftentimes, especially in high-value contracts or involving high-value data, provisions that expressly obligate them to maintain that insurance throughout the term, perhaps even provide certifications or descriptions and information about that insurance to you so that you can be assured that they have the coverage that they need to actually pay out the liabilities that they've committed to in the contract. Because if the money is not there, it doesn't really matter what the contract says. And insurance is one way to make sure that a vendor, particularly a vendor that may not have a whole lot of cash on hand, a smaller startup-oriented or smaller regional player, actually has the liability allocation needed to cover a serious third-party claim or a serious data breach. And lastly, within the one remaining minute that we have left, I'll speak very briefly about audits. I saved this for last because Kelly also kind of covered this a bit. But keep in mind, too, that in addition to the mandatory auditing procedures that may be prescribed by law, such as the GDPR, you also have the ability to insert in here a contractual audit procedure that supersedes that and gives the parties a private audit right, perhaps through a third-party auditor. It has to be robust. It has to describe things in a careful and specific way. But this can be a good way to make sure that your IT professional is not only comfortable ahead of time, but can continue to be comfortable throughout the term with the type of security obligations that apply to your vendors. And that does it for my side of the presentation. We probably don't have time to cover any of the many questions that came in within the end of the hour. But I know my colleagues have informed me that we will be taking these questions, summarizing them, and preparing responses separately for distribution to the attendees at this presentation.
Before we close, one of the questions I was looking reminded me that I forgot to say the CLE code in the middle of the presentation. The CLA code is Data 2021, and that was my mistake. I was supposed to say it during the handoff. So thank you to whoever reminded me.